Our last case this afternoon will be People versus Garcia-Mandujano. Please wait for a moment. Okay, this will be 15 minutes per side. Mr. Burns.
Thank you, Your Honor. May it please the Court, my name is John Burhans, appearing for the appellant. I'll reserve 2 minutes for rebuttal and waive the free fire zone after 2 minutes. My client believes that his conviction and sentence ought to be reversed because it was tainted by a denial of effective assistance of counsel in 3 respects. One, the failure of trial counsel to be prepared for the testimony of a physician's assistant who testified that she used an adult speculum on the complainant, which was not in her report and which was a surprise to everyone, especially trial counsel. The second reason was that once confronted with the surprise testimony of the physician's assistant, trial counsel failed to impeach the physician's assistant because of the lack of any mention of the adult speculum in her report. And finally, the failure of trial counsel to interview or call any witnesses who were living in the trailer at the scene of the crime to testify as to the crowded living conditions and that a crime of that sort, a rape in one of the bedrooms of this small single-wide trailer, could not have taken place without being observed or noticed by the large number of people that lived in that trailer. I think it's important to point out, first of all, with this report was in the police report, which was made available to trial counsel months before the trial, I believe in March of 2014, and the trial took place in September of 2014. There was a reference to an examination. There was a reference to some of the details that occurred during the examination in the police report itself. But counsel did not even ask for the report until about 12 days before trial. So even at that point, there was time to get the report, take a look at it, which he did, and then request an interview with the physician's assistant to ask questions about that to make sure that there was no other medical evidence, because clearly what he wanted to do was use the report to ask leading questions that there was no medical evidence, no physical evidence other than what you have in this report. In other words, no DNA, no tears, no lacerations in this rape of a 12-year-old that was alleged. And then to confine the witness to what is in her report. Instead, he asked a few open-ended questions, and this is on cross-examination, not on direct examination, because the prosecutor produced this witness. And then everything blew up. This highly sensational, stunning revelation that an adult speculum was used by the physician's assistant on this 12-year-old, and that it fit inside of her very easily, was the only physical evidence in the case. And it was presented to the jury in that fashion, both in terms of the evidence that was presented and in closing argument by the prosecutor, who very ably used it in what I call 3 forays into the use.
Help me understand, what exactly is the critical error? Is it the failure to interview, or is it the failure to use the report to cross-examine?
I think the failure to interview.
All right, well, even if he interviewed,
right,
and he discovers that she's going to testify at the speculum, then what?
Then at least she's prepared to show that whatever her testimony is wasn't in her contemporaneous report from the year before.
Okay. Why do you need an interview for that? You've got the report. It says what it says. The testimony's coming out, and it's not consistent with the report.
I agree. I think in this particular case, just call it he's caught off guard or surprised by it. And anytime you're caught off guard, even in the middle of a trial and cross-examination, you've prepared for everything else, it can be disorienting, disconcerting, and so on.
You agree that the report as written is favorable to the defense?
Well, it has statements in there from the complainant, right, about the rape and so on. So.
But there's no evidence of tearing. There's no physical evidence to
The
corroborate.
physical evidence is favorable.
The lack of physical evidence is favorable.
Correct. What it doesn't show about the physical evidence.
And the fact that the speculum is not mentioned in the report would discredit that testimony, wouldn't it?
I think it would. I think it would.
So
I think it
compounds. I'm having a hard time why you have a duty to interview when you've got a favorable report there. And maybe we're just going back and forth over details. I mean, I'm more concerned about the counsel's failure to do a cross-examination that you should understand and know how to do right out of law school than I am that someone who's mentioned on the witness list wasn't interviewed in advance of trial.
I agree with that. And going to the first question, I think that is the core of the denial of the effective assistance of counsel, the failure to impeach in the first cross-examination, and then the failure to impeach on the second cross-examination or the recross-examination when...
Failure to impeach at any point, really?
No. He thought he did in the motion for Ginther hearing. He thought he had cross-examined or impeached the witness on that, but he hadn't. And it allowed... there were a number of things. It allowed the prosecutor to jump on it and exploit it, as you expect he would. And the report was not put into evidence. And so defense counsel couldn't argue in his closing argument that, okay, she testified to this, and even though I didn't cross-examine her or impeach her on that, I can't now even argue in closing argument that what her testimony contradicted what was in her report.
But I thought that was in fact done during closing argument. I mean, I understand how it would have been better if there had been a more aggressive cross-examination, and you're correct that the defense counsel seemed to have been caught off guard, but isn't it fair to say she was only temporarily caught off guard because it was raised during closing argument? Or am I mistaken on that?
Well, I go back to the two opportunities to impeach the physician's assistant that was not done, and which was, I mean, just sitting there waiting to be done.
But didn't she argue this discrepancy to the jury?
There was an oblique reference. He said you can be sure that if that was in the report, then it would have been brought out. That was the only reference. It wasn't like, okay, here's the report, here's her testimony, and the report says nothing about this sensational testimony that she gave about the adult speculum, which could lead to a number of conclusions, namely one, that she's lying, or that the examination never took place. None of that was set forth before the jury, and I think because of that, and because it was basically a one-on-one credibility contest, he was severely prejudiced by that. I think it's important to look at the compounding of the error by trial counsel when he is cross-examining the physician's assistant about it. I think the people make the argument that, well, he just wanted to leave it alone. Unfortunately, he didn't leave it alone. He kept going at it on the cross and the recross examination, and the physician's assistant being asked questions continually by him and also by the prosecutor on redirect examination when he found out about it. She just kept elaborating on it, and it just dug a hole that got deeper and deeper and deeper. So I think when you start off with a failure to know what's going on and then assuming that you're genuinely surprised or wouldn't have known about what the physician's assistant was going to say, even if you did interview her, when you're confronted with it, you have to be able to challenge the witness on something that, in my opinion, was a tiebreaker in this case. I don't think there's any question about it. I think the jury, having heard that testimony, now had the physical evidence that they would use to break this one-on-one credibility contest tie.
If counsel tried to interview the physician's assistant?
He did not try.
But if counsel had, could the witness have refused to talk to him?
There's always that possibility. There's always that possibility, which would lead to some suspicions as to why she wouldn't, because the privilege, physician-patient privilege, had been waived. And I think that it might have heightened his radar to expect the unexpected, so to speak.
So attempting to interview would have been valuable.
Very much so, very much so. But he's there at the podium examining the witness. He's got the medical report. I mean, he's looking at the medical report, and he's going through the medical evidence that's not there, and then all of a sudden there's this medical evidence that is there. And just the failure to confront that, I think, led to the denial of effective assistance of counsel in that respect.
So there was a going through the report and identifying what's not in it, which would be good cross-examination. Would you agree?
Right. When I looked at it,
then we get to the speculum, and instead of sticking to the report, he wants to argue anatomy with a healthcare provider.
He's arguing anatomy. He admits that he's not an expert on female anatomy.
Okay.
As the jury told him.
Look, it's not ideal, but given the fact that he got out of this witness all of the absence of physical evidence, how do we get to the point that any error that was there is outcome determinative?
Well, the absence of medical evidence is good if it stops there. When you get to the point where you're not talking about absence, but presence, and the medical testimony that comes out of nowhere is what it was. I mean, you've all read what the testimony was and how it became the elephant in the room. I mean, it's there. You've got to do something with it. You just can't ignore it. And now that it's been thrown in your lap, and you just didn't deal with it. I mean, if you're a jury, you have no idea that
so
this didn't exist.
So it comes down to just this simple proposition. The failure of counsel to say to this witness, you're saying all this today, but it's nowhere to be found in your report, is it? Right?
There'd be
failure for that one question is outcome determinative in this case?
I think it'd be a series of questions.
Especially when there was some allusion to this made to the jury during closing argument. It may not have been as effective as you would have liked to have seen it, but it wasn't nothing.
I think it would lead to a series of questions on cross-examination. Is this a significant finding? Is it the kind of finding you would put in a report? Is it something that you would disclose to the prosecutor or to other health officials? So you're right, it's one area, but it's a series of questions.
It's really one or two questions, though, isn't it? You're telling us this is important today, but it wasn't important enough to put in the report, was it?
Correct.
And that's outcome determinative? One question?
On one huge area with one huge piece of evidence, he didn't ask any of those questions. So whether it's one
or down to one question, though.
Well, whether it's one or I like to build foundations and then go ahead and make what you're saying.
No evidence of tearing, which was asked, I think. Right?
More evident. But
right.
I mean, the fact that it's a speculum, that it was an adult speculum, the fact that it fit in so easily, all of the testimony that the witness gave that would lead one to believe that this young girl has been raped, obviously, and multiple times. By who? The only person they can point to is the defendant, because there's no other medical reason, because there's no expert there to counter what this physician's assistant has said. So one question, one area, one huge issue. I think that changed the balance of power in the case and was a game changer. So I think it was a denial of effective assistance of counsel that changed the outcome of the case. Now, the third issue that I had was the failure to call witnesses who were in the trailer. This is another example where it's alleged that a decision was made not to call witnesses, when in fact there was no decision. It's a non-decision decision. It's a abdication of the responsibility to interview people who were living right at the scene of the crime, who could testify, as they did in the hearing on the motion for, or the Ginther hearing, that they were all there. There were 8 or 9 people there, and it's just not the kind of activity that could take place in a bedroom in the small trailer that would go unobserved or unnoticed. So I think when you combine all those elements of the claim of denial of effective assistance of counsel, I think that Mr. Garcia did not get a fair shot, and the jury would have seen things differently had those witnesses have been produced and had the proper cross-examination taken place.
Thank you.
Thank you very much, counsel. Mr. Prosecutor?
Good afternoon. Assistant Prosecuting Attorney Eric Jenkins, on behalf of the people seated at the table to my left, is co-counsel Prosecuting Attorney Michael Bedford. I want to touch on the second issue, and the court has kind of touched on this already a little bit. I would also waive my 2-minute free fire period. The idea that the trial counsel failed to cross-examine on whether or not this was in the report or not, I think it's noteworthy that the court has already said it's 1 or 2 questions, but I also think it's noteworthy that it was brought up in the closing argument by trial counsel. It wasn't something that was totally left out of the record. It's quoted in my brief. There's a very extensive portion of his cross-examination where he says, if this had been in a report, you can guarantee that the prosecutor would have been the one to bring that out. I also think it's important to note that he doesn't just back away from cross-examination on that issue entirely. He may not specifically go to, why isn't this in your report? But later on in his cross-examination, he does a pretty good job of getting her to give the concession that she'd never performed this speculum examination on the victim before. And while that's not maybe the avenue some people would pursue, I do think that's an important avenue to pursue, because he gets the concession that she doesn't know that this is anything that's coming from the defendant. I mean, he can make that inference, and he in fact does argue that in his closing statement.
Counsel, I agree with you, everything you're saying. I do think those things are important to weigh in the balance here. But I also think something that your side said during closing argument is equally important to weigh in the balancing. You told the jury that defense counsel here made a huge mistake by not interviewing the PA before trial, because everyone knows that, quote, a lawyer should never ask a question if he doesn't know the answer to it. You also stated he could have called her up and said, hey, I'm going to ask you on the stand, was there anything in your physical examination or your findings that would be indicative of this type of assault? But he didn't, and he helped you get more truth. You then went on to explain why this testimony was so damaging to the defendant, and now in your appellate briefs to this court, you're suggesting, well, it wasn't all that big a mistake, and it sounds to me like that's where you're heading right now, too.
It is where
How do you balance all this?
And I think part of the context of that statement is in the rebuttal closing argument by the prosecutor, and it goes directly to the defense attorney arguing that this witness was a liar. So at that point, he's trying to rebut the test, or to rehabilitate that testimony after the closing argument of the individual. And I do agree the wording is not the greatest, although it's not his opinion as to whether or not it's a huge mistake. It's obviously this court's, and in the Ginther hearing, the trial court's opinion as to whether or not that's a huge mistake that this individual made. Again, I do say the phrasing is a little bit tough to deal with in terms of saying a huge mistake, but I do think it's important to remember the context that's being done in response to the trial counsel's assertion this witness is lying, that they're biased and things like that. I mean, this is a trial. Things are happening in real time. Things are going on. He's reacting to what trial counsel's trying to say about this witness. And I think the testimony, I mean, obviously it's something that either side can argue one way or the other. For the prosecutor, obviously you're going to argue this is important evidence. For the defense side, you're going to argue that this is not important evidence, or there's something else going on here. I think trial counsel did at least a decent job of trying to impeach that witness by saying, well, you don't even know if this is something that's there before, how you've never done this examination on this person before. I think that's important to remember in terms of why that comes out on the record. I also tend to agree that this is the idea of not interviewing her. I don't think that falls below reasonable standard for counsel. I mean, there's a report, as the court
I'm troubled by that aspect.
Okay.
Because, frankly, I know how the prosecutor's offices generally make witness reports. They give it to someone low level and say, if there's any name in this file, you put it in the report. And so making a general rule about having to interview people listed on the witness list is a little bit troublesome to me. But what you have here is a report you know is going to be critical. And I'll say you don't even have to interview because you know this report is pretty much favorable to you. There's a lot you can do with this report. But when she comes out and says something that's not in the report, how do you not ask the question, if this is so pertinent, why wasn't it in your report? It seems to me basic impeachment cross-examination that everyone should learn in law school.
And I agree, it is basic impeachment that everyone should learn in law school. I guess at this point, for appellate courts to say you went down Avenue A, you should have gone down Avenue B, I think that gets into the sort of cautionary note that Strickland has in it, which is that we don't want to have a trial within a trial.
But either if it's not going to be that we require you when you have a report to try to interview the witness in advance, you better be pretty damn familiar with what's in that report. And when something is not consistent with that report, competent counsel, I would say, should be prepared to then cross-examine on that. So you can't have it both ways. Either he should have interviewed and known what was going to come out and prepared that way, or been prepared with the document itself to do a proper impeachment. It seems to me that this is something that's absent. And then I go to the closing argument. Oh, good. There's something in the closing argument I can look at. I look at it. I don't quite understand what he's saying. What is he saying in the closing argument?
You mean defense counsel?
Yeah.
I think at one point he's saying specifically that that's not in the report. He's alluding to the fact that everyone was surprised by that and then it wasn't in there to begin with. And then he uses that to kind of branch into a bias argument about this physician's assistant.
The PA in her belated claim admitted that it doesn't really mean anything. It doesn't really tell us anything. And I guarantee you if it was in her report, Mr. Bedford would have brought it out in his opening and would have entered that report. It was clearly a belated claim by a very biased and supportive physician assistant. She wanted to support. And then, I don't know what's after that.
Yeah, I don't have the quote after that. I've got the same spot right here in front of me.
I mean, admittedly, I didn't sit through the trial. I don't know if it all makes sense to the jury, but help me make sense of it.
Well, I think that the witness that we're talking about, this physician's assistant, came off as very biased in the trial. It was clear that she was trying to get information out. That she doesn't offer this information to the prosecutor during his direct examination. She waits until defense counsel's up there and gets this out. And I think it's even more, it's noteworthy when he does begin to ask her impeachment questions specifically about whether or not she'd done this examination before. She gives a non-responsive answer at that point and goes directly back to this issue of the speculum. And I think it's pretty clear from the entire breadth of that cross-examination that she's trying to get this information out in a biased fashion, and that's what he's saying there. So I understand that.
Doesn't that trouble you if your witness is trying to get information out in a biased way?
Well, yes.
You're the prosecutor?
I mean, it is troubling, but it's something that happened during the trial, and both parties are dealing with it at that time.
Let me ask you a related but more specific question to sort of tie it all up. When there's the issue of the failure to cross-examine, but there's also the issue of asking the open-ended question that your office described as a huge mistake. Shouldn't we be thinking about whether that's ineffective assistance? So maybe you didn't interview the expert because the report's favorable. There's some law out there that suggests that that's okay. But then if you're going to use the report as sort of the centerpiece of your cross-examination and ask the open-ended question, the question, why shouldn't we conclude, like your office did in closing argument, that was a huge mistake?
I think part of the problem with that is that you were getting into nitpicking individual questions throughout a trial counsel's representation of their client. I mean, if we did that in every case, if we made
we're
that
not nitpicking all of them. This was sort of the big one, right?
Okay.
This was
These specific questions. It could have been asked in an open-ended way, could have been asked in a direct way. I think we're getting into the avenue of beginning to dictate to a trial counsel who's trying to, they're experiencing a living, breathing trial. I mean, trials are moving parts. They're living. They're basically breathing. I always describe them to people who ask me as, it's like the biggest test you ever had that fights back. Sorry, what's that?
Fast and furious.
Fast and furious. I say it's the biggest test you ever had, except it punches back. I mean, that's what you're dealing with when you're in trial.
I mean, I don't disagree. I sat through a whole bunch of them when I was a trial judge, but the secret to being a good lawyer, I think everyone here would agree, is preparation. So you're prepared for all these different things that that come up, and also preparing your cross-examination, you think the first thing you're taught in law school is to not ask questions that you don't know the answer to in front of the jury.
As the prosecutor pointed out in his closing argument.
Right.
I think it's also not lost that he had a very specific aim in getting this witness on the stand and cross-examining her, and that was that it's not just the lack of physical evidence. His whole theory of the case was that this witness gave differing statements to different people with different times and dates and different details, and he got that out of her in the very beginning of that cross-examination. I think he may have gone one question too far. I think the issue with that in terms of granting application or reversing or remanding is, are we going to punish counsel for going one question too far? I mean, that happens in trials.
So why don't you then go down the path of trying to persuade us that it's not outcome determinative?
And I don't think it is. I really don't think that in the end this is outcome determinative. You know, there's a lot of cases I cited in my brief, cases like Ackley, Trachtenberg, Armstrong is in there, a Grant, these cases where there was a failure to investigate and things that were, I say, left on the cutting room floor.
I remember all those cases, they went in favor of the defense.
They did.
Okay.
And I'm saying they're different than this case. In those cases, you had exculpatory evidence, you had a completely expert-centered trial where defense counsel refused to or did not call. They called one expert who said, I'm not the guy for you, I'm on the prosecutor side in this issue, here's the name of somebody else. They didn't call them. And those cases are all, I think, distinguishable from this situation. Those errors by counsel or those missteps were such that they really did call into question the integrity of the trial. This is a situation where you got a little more information from this witness, but you're not dealing with a situation where you look back on trial counsel's failure to investigate and you realize there are 4 or 5 witnesses who could have absolutely refuted what the prosecution was trying to convince the jury of. And I think that's the difference here, and that's where this is not outcome determinative in terms of what happened. And I think the credibility of the victim was always the thing that was at issue there. I think the speculum evidence kind of goes against it, kind of distracts from that issue, which was that always the center of this case was the credibility of the victim. I think the jury, when watching her testify and how she held up under cross-examination, that was the real crux of what this case was about, was how she presented to the jury and what her story was. And I think that's why, you know, obviously there was some more information that came out, but I don't think it's outcome determinative that makes us think that the defendant got an unfair trial, that he was not guilty and somehow found guilty based upon what was put on the record. And that's why I bring up Ackley in cases like that, where the information that was presented to counsel or that could have been investigated was so compelling that it really showed this guy may not be actually guilty. There were other witnesses. I think Grant's a good example where it was a CSC case where the victim, there was actually tearing, I believe, in her groin area, but there were witnesses that could say she fell off her bicycle several days before this happened, and it was the injury in the same area, and defense counsel just ignored that. That's information that when you're not presenting that to the jury or not following up on that is such that you really go against it.
Okay, I don't want to beat a dead horse here, but you got a lot of things that are favorable that are not in the report, the lack of tearing, the lack of bleeding, all this lack of physical evidence. But then when the testimony comes out about an adult specular, that would explain why there's none of this tearing.
Well, and another thing I want to point is it's almost non-responsive to the question. I mean, he asked about physical evidence is what he asked about, and then she brings up this speculum issue that has nothing to do with what he was trying to drive at in that question. I mean, he was talking about the tearing, the bruising, anything like that, and she answers with this question. It's kind of off the range of what we're talking about in that report. I mean, there's no mention of it anywhere. There's no mention she performed a speculum exam at all. So again, saying it's not
to strike is non-responsive. Was that in the record?
No, it was not. Yeah, he did not follow up on that.
Where's that in your report? Is that in the record?
Nope, he did. And then again, the only record of that is when we get to this closing argument that he makes, where he tries to shore up that issue and bring home that this was something that was not mentioned in her report, and that she seemed to want to get that out to him at that time. So I think, you know, one of the things I seem to look at when we're talking about whether or not to grant application on this case or whether or not to reverse and remand, I do think that we're talking about 1 or 2 questions here that I don't believe are outcome determinative. I do think that if the court starts to look at that sort of stuff, those 1 or 2 questions, and say, yeah, this is something you should have asked A versus B, or the best way to cross-examine someone, as we've learned in law school, is to, hey, why isn't this in your report, as opposed to saying, you've never performed this examination before. We really do get into this cautionary note that I've cited in Strickland, which is that,
Cross-examination by hindsight.
yes, we're starting to have a second trial where the issue at trial was how defense counsel performed and whether or not they made the mistakes or asked the questions or did the things that somebody else would have done. And I think that Strickland's very clear they don't want appellate courts to be in that position. I think the trial court during the Ginther hearing made some good inroads into questioning this individual and then making the ruling that, you know, it's not unreasonable to rely on the report of somebody, especially an expert witness. This person is a professional. It's very much believed that somebody who's a professional like that, what they put in their report is what they're going to testify to. You could say the same thing about police officers. I don't know how many times I've called a police officer about testimony and they've said, I got to reread my report because that's what I'm going to be basically looking at to remember what happened here. I don't think that's unreasonable. I think that when it comes to this cross-examination issue, I think while counsel may not have made the choice that I would have made or somebody else would have made in not asking why this wasn't in your report, at the same time, they also go down a different road of cross-examination. They do try to impeach this witness, and they do try to get out of this witness that they really don't know what this is from, and then he argues that to the jury later on. So I think, just to give my summation of what the issue here is, I think that one or two questions where one thing comes out that is not expected, that happens at a trial, and to begin to change trials or reverse trials based upon that will get into a very slippery slope. We'll be looking at everything with such scrutiny that trial counsel may not be able to be effective and may not ask the questions they want to ask at trial. So I thank the court for the time. I appreciate it.
Thank you, counsel.
Thank you.
Mr. Burns, I think your time is up, too. I think your time is up.
Oh, time is up.
Yeah, I'm sorry.
Well, thank you both, because I thought the argument was helpful in a very difficult case.
Okay. Well, we stand in recess until tomorrow at 9:30. Thank you all for being here.